live from the drama-free true crime destination. No doubts, no delays, just the facts, the fire, and the finality that stands tall. This is the final word.
And a good Friday late evening to everybody. Give me 1 second, get my mic set right. And
there we go. Welcome over to a late Friday evening here, the drama-free true crime destination known as Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. So good to have you back in the house. And I've got a lineup of legal headlines and news to bring to you. But before I do that, as always, I am going to kick things off with my opening statement. Tonight, among the cases that we'll cover, we'll step into 4 courtrooms, bringing 4 tragedies and 4 very different portraits of accountability. In Texas, the nation watches as former Uvalde school officer Adrian Gonzales stands trial, accused of failing to act while a gunman murdered 19 children and 2 teachers. Prosecutors say he had over a minute to intervene and didn't. The defense says he's being blamed for a system-wide collapse, but the question remains, what is the duty of protection when children are dying? In New Jersey, the Caneiro trial finally unfolds 7 years after a mansion burned and a family of 4 was found murdered. Prosecutors say Paul Caneiro killed his own brother, his sister-in-law, and their 2 children over money, then set 2 homes on fire to cover it up. The defense insists he's innocent, but the evidence tells a story soaked in betrayal. In Ohio, a surgeon named Michael McKee is indicted for the execution-style killings of his ex-wife and her husband. Investigators say he crossed state lines, used a suppressor, and left 2 children orphaned in their own home. A history of threats, a trail of digital evidence, and a motive rooted in obsession now sit before a grand jury. And in Virginia, prosecutors say Brandon Banfield, an ex-federal agent, plotted with his family's au pair to lure a man into a deadly trap, kill him, and murder his own wife in a staged home invasion fantasy. A scheme built on deception, fetish sites, and a plan to get rid of his wife. The au pair has flipped. The jury now hears the rest. 4 cases, 4 states, 4 different kinds of violence. But as always, there's one truth. If justice is anything, it's never simple, and it's never optional. Welcome to the final word, guys. We're going to go ahead and get on our jump off here. And we are going to start things off not with any of our 4 major stories, but we're going to actually take this one back to a classic, if you will. The prosecutors are pushing back on Lori Vallow Daybell's appeal in the murders of her children. And given what we know, I can't say I blame them. We're going to Boise, Idaho to start off with. Idaho prosecutors are urging the state Supreme Court to uphold Lori Vallow Daybell's life sentence for murdering her two children and conspiring to kill her husband's former wife. Ooh, excuse me. Systematically rejecting each of the five constitutional claims raised in her appeal. In a 59-page brief filed Tuesday with the Idaho Supreme Court, Deputy Attorney General Jeff Nye argues that the trial court properly handled every issue Vallow Daybell raised, from the disqualification of her chosen attorney to the admission of evidence about prior deaths in Arizona. Lori Vallow Daybell was convicted in May 2023 of murdering her children, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan, as well as conspiring to kill Tammy Daybell, the first wife of Vallow Daybell's husband, Chad Daybell. The children's remains were discovered buried on Chad Daybell's property in June of 2020, months after they were last seen. She was sentenced to serve 3 life sentences without the possibility of parole. Her appellate attorney, Craig Durham, filed an opening brief in May, arguing Vallow Daybell deserves a new trial based on 5 constitutional violations. The Sixth Amendment violation, saying that the trial court improperly disqualified her retained attorney, Mark Means, depriving her of her right to counsel of choice. A second Sixth Amendment violation, saying she was denied the assistance of counsel during pretrial hearings when the court refused to allow Means to participate in hearings about his own disqualification in Chad Daybell's separate case. There's a due process violation. The trial court held pretrial hearings that affected her substantial rights while she was absent and incompetent to stand trial. There's the evidentiary error, saying the trial court improperly allowed evidence of uncharged bad acts from Arizona under Rule 404B of the Idaho Rules of Evidence. And the speedy trial violation. The nearly 2-year delay between indictment and trial violated her statutory and constitutional rights to a speedy trial. The state's response filed this week addresses each claim in detail. First, there was the attorney's conflict of interest. The most significant issue in the appeal centers on the trial court's decision to disqualify Vallow Daybell's attorney, Mark Means, whom she had retained to represent her. Prosecutors argued Means had an irreconcilable conflict of interest because he simultaneously represented both Vallow Daybell and her co-conspirator husband during the alleged conspiracy. The state's brief reveals that Chad Daybell arranged and paid for Means to represent his wife. In April of 2020, Means publicly announced on Twitter that he represented Chad Daybell, posting, "Please note." It's supposed to say no, but he forgot the E in his spelling. "Please note that this office," notice being provided by other means as well, "represents Chad Daybell. If any agency, investigative authority, etc., wishes to contact my client, please contact my office directly." On the same day, in a jail communication with Lori Vallow Daybell, Chad stated, "Mark Means is my attorney," and alluded he had shared confidential information with Mr. Means that Daybell believed would be covered by attorney-client privilege, according to the brief. Oh, there's so much. There's a competency proceedings, sends about evidence from in Arizona, the speedy trial claim, and the bottom line, here's what's next. The Idaho Supreme Court has not yet set a hearing date for oral arguments in the appeal. Lori Vallow Daybell's appellate attorney may file a reply brief responding to the state's arguments. Chad Daybell was convicted in May 2024 of the same murders and sentenced to death. His appeal is pending separately. Ladies and gentlemen, I'm telling you right now, just the way that just it just droned on and on and on. I'm telling you guys, that one, it's not gonna work out in Lori Vallow Daybell's favor. It's not gonna work in her favor. So she needs to come up with a new plan because this one is gonna go right down the tubes. Okay, from one other case that I've been following for quite a while to one of the first cases that got me into the true crime community in the first place. Tim Ferreter. Remember that name? Tim Ferreter is appealing the boy in the box conviction, and he's arguing that Arizona evidence tainted his trial. First Lori Vallow Daybell's blaming Arizona evidence. Now Tim Ferreter is trying to blame the Arizona evidence. This one I'm gonna let you guys see for yourself. Okay. Okay, now that I'm set. Oh boy. No. All right, we're going back to West Palm Beach, Florida. An appellate court ordered arguments on Thursday in the case of a man convicted of locking his adopted son in a windowless garage room, with defense attorneys arguing that evidence of prior abuse in Arizona unfairly prejudiced the jury and should have never been admitted at trial. 48-year-old Tim Ferreter was sentenced to 5 years in prison in 2023 after a jury convicted him of aggravated child abuse, false imprisonment, and child neglect for confining his teenage son in an 8 by 8 foot box in the family's Palm Beach County garage for 45 days. The boy, known publicly only as RF to protect his identity, had no control over lights or air conditioning and was forced to use a bucket as a toilet. During oral arguments before the 4th District Court of Appeal on January 8, 2026, Ferreter's apparent attorney, Leon Fewer, argued that the trial court abused its discretion by allowing prosecutors to present extensive evidence about how Ferreter treated his son during the 3 years the family lived in Arizona before moving to Florida. The evidence of abuse in Arizona was so much more severe than the 45-day period in Palm Beach County, Fewer said. It was also unduly prejudicial, unfairly prejudicial, should have never been admitted. According to court documents, the Arizona evidence included testimony that Ferreter smacked his son in the face, grabbed him by the neck, hit him with a jump rope or belt, and held him up against the wall. Ferreter's daughter testified that she feared her father would kill her brother in Arizona, and that she would hear sounds of slapping or hitting, followed by her brother's screams. Fewer argued that the Arizona evidence became an impermissible feature of the trial, particularly when the state's expert witness, Dr. Wade Myers, incorporated it into his testimony. The expert repeatedly stated that the son was in solitary confinement for 3 years and testified that the treatment constituted torturous behavior that could not be justified under any circumstances. Once you ring a bell, you just can't undo it, Fewer said. The defense attorney also argued that Dr. Myers improperly testified about the ultimate issue of guilt by negating Ferreter's defense theory that his actions constituted reasonable parental discipline of an out-of-control child. Fewer said the trial court prevented the defense's own expert, Dr. Rappaport, from offering similar opinions supporting the defense theory, creating an unfair imbalance. Assistant Attorney General Rachel Goldblum countered that the Arizona evidence was properly admitted because Farrer's primary defense was that his actions were a reasonable response to his son's escalating and dangerous behavior. If that behavior is allowed in, and we're looking at whether the defendant's actions were malicious, neglect, neglectful, or torturous, excuse me, then we also need to have a full context of how he addressed the child's behavior over that period of over that time period, Goldblum said. She argued that the Arizona evidence showed a continuing course of action, not a desperate, last minute, isolated attempt to address certain problematic behavior. Goldblum emphasized that the state focused on the majority of its evidence on what occurred in Florida, presenting approximately 8 hours of ring video footage in from the garage room. By contrast, by the state presented no video evidence from Arizona, relying only on testimony from the victim and his sister. This is a lot to go with. Farrer's wife, Tracy, just jumping ahead, was charged with the same offenses, but she accepted a plea deal that allowed her to avoid jail time. Lucky her. She was sentenced to 10 years of probation and 300 hours of community service. The appellate court did not issue a ruling from the bench, but a written decision is expected in the coming months. My opinion, Tim Farrier needs to go ahead and give this one up now as well. But I will say that he does have at least a better shot in his appeal than Lori Vallow Daybell. That being said, I'm not gonna put any stock into actually getting his appeal granted. All right, next up, a Kentucky cold case has been solved. Let's check that. The case has been linked to the Texas yogurt shop murders. In Lexington, Kentucky, Lexington police have solved a 27-year-old homicide case, identifying the killer of Linda Marie Rutledge through advanced DNA and ballistic evidence that connected her 1998 murder to the infamous yogurt shop murders in Austin, Texas. Personal crimes detectives officially closed the case in November 1998 homicide of Rutledge, bringing justice to the 43-year-old woman and her family after nearly 3 decades of investigation. That's according to a release from the department. Officials detailed that on November 7th, 1998, at around 7:40 a.m., the Lexington Fire Department responded to a structure fire at the Nixon Hearing Aid Center in the 100 block of Malibu Drive. When crews arrived, they observed heavy smoke coming from the business and made entry. The fire was extinguished quickly, and Rutledge was found dead in the back hallway. The Fayette County Coroner's Office determined Rutledge's cause of death was multiple gunshot wounds to the head. Over the past 27 years, detectives and investigators continued working on the case, reviewing notes, re-entering evidence, following up on leads and tips, and researching how new technologies could help further the investigation. Lexington police reported that the breakthrough came in July 2025 when detectives were contacted by the Austin Police Department after they received a match from the National Integrated Ballistic Information Network regarding a .380 shell casing recovered from the Nixon Hearing Aid Center. The shell casing matched one located in Austin in December of 1991 after the yogurt shop murders, according to police. The Kentucky State Forensics Lab examined the 380 spent shell casings from Austin and Lexington, Kentucky, and preliminary comparisons revealed the spent shell casings came from the same firearm. In addition to ballistic evidence, DNA evidence from both cases also matched. In September 2025, a sexual assault kit from Rutledge was sent to DNA Labs International for testing and matched the profile from Austin. The suspect was identified as Robert Eugene Brashers. Brashers has been dead since January of 1999, police reported. If he were alive today, he would be arrested and charged with Rutledge's murder, the department's release said. This guy was going all over the place. He was out on bond when he killed Linda Rutledge, said Ian Kane, or Ian Kane, if I'm pronouncing it right. If not, hold it to my head. Kane, the co-host of the Murder Sheet podcast, which recently covered Rutledge's case. He had broken into a woman's house in the spring. He had broken into a woman's house earlier that year, got minded out, then came up to Kentucky and murdered Linda. So I think whenever this guy was not in prison, we need to be considering that he may have been doing some crimes, and we need to be looking at what those are. The case highlights Brasher's criminal pattern and raises questions about other potential victims. Margaret Brown, who directed an HBO series about the yogurt shop murders, described a far-reaching impact of his actions. Just the ripple effect on so many people is so immense, Brown said. The series that I made, it was really just about how the trauma sort of extended outward, starting with, of course, the families and people who were wrongfully accused, the cops who worked on it, the people who were making other films about it. It was just, you would see these ripples of so many people affected by this one man's action. Kevin Greenlee, co-host of the Murder Sheet podcast, emphasized how law enforcement collaboration can help solve other cases. Once they solve a crime like this involving DNA, they pool their knowledge, they talk to one another, and they help other agencies solve their crimes. So Lexington has been helped. Lexington is going to help other agencies. And at the end of the day, there's going to be more justice for more victims because of this amount of teamwork. Brown expressed hope that having answers will provide some peace for the Rutledge family. I think knowing versus not knowing is always a good thing, Brown said. I think it seems like it just talking to the families that I know that's it's just something that you can that I can stop spinning in your head. Rutledge's family is asking for privacy as they process this news. Police say if Brashers were alive today, he would be charged with Rutledge's murder. The Lexington Police Department thanked multiple agencies for their assistance, including the Austin Police Department, the Office of the Attorney General, the City of Austin Forensic Science Department, the Kentucky State Police Forensic Lab, DNA Labs International, the ATF, the FBI, and Lexington Fire Department. The department also thanked its detectives, forensic services unit, and investigators who remained dedicated and continued working on the case over the last 27 years. But most importantly, the Lexington Police Department wants to honor Linda. Her life was cut short at just 43 years old, and her family has had to live with the pain of losing her and not knowing who took her life. While the case may be solved, it does not bring Linda back. But we hope that by knowing who killed her, her loved ones can begin to heal, the department stated. Their statement on X said, "We are proud of the KSP Forensic Laboratory for assisting with the 1998 homicide of Linda Rutledge after nearly 27 years. Through detailed ballistic analysis and the advancing forensic science, our lab helped provide critical answers." And they left links to watch the Yoga Shop Murders on HBO, and to listen to the Murder Sheet podcast on Linda Rutledge. But first, again, to all those agencies, I want to give them a shout out and recognition for all that they've done to solve that cold case. Great job. Great job. I mean, now true, while it's 27 years and the case is finally solved, but still it doesn't bring Linda back. But now at least the family can find some peace, get some closure for the loss of their loved one. Let's see what we got next. Oh, okay. Here's one of the big four. This is one of our big four cases this evening. The ex-husband charged in the murders of an Ohio couple. In fact, I may just go ahead and start focusing on the big four. The four biggest, the big four, the four biggest cases we got going on right now. As you see on the screen there, this is on back last week. Michael McKee was arrested in Illinois. Let's run this article courtesy of the Associated Press. The ex-husband of an Ohio woman was charged with the murders of her and her husband, according to court and county records. 39-year-old Michael McKee, who you see on the right side of your screen, was booked last Saturday and is being held in Illinois, according to the Winnebago County Sheriff's Office. He is alleged to have shot and killed the couple, Dr. Spencer Tepe, a 37-year-old dentist, and Monique Tepe, 39, in their Columbus home. There were no county court records in Ohio reflecting whether McKee has an attorney yet. Dispatchers first received calls of concern, including from Spencer Tepe's boss when he didn't show up for work, which the boss said was out of character. Columbus police discovered the Tepes on the second floor of their home on December 30th with gunshot wounds. When officers conducted a wellness check, their two children were in the home and unharmed, police said. Police released security footage earlier this week of a person of interest in a dark hoodie and light-colored pants who was walking in an alley near the couple's home between 2 a.m. and 5 a.m., the window of time in which investigators believe they were attacked. Official reports from the Franklin County Coroner's Office won't be completed for several weeks. But a spokesperson said in a Tuesday email that the couple died in an apparent homicide by gunshot wounds. McKee and Monique Tepe married in 2015 and filed for divorce 2 years later, according to records from the Franklin County Clerk of Courts. McKee's address is listed in Chicago. Monique and Spencer Tepe were married in 2020, according to the couple's obituary. Family members describe the Tepes as an extraordinary people and proud parents with joy-filled lives. Monica Tepe was a caring and bubbly stay-at-home mother. and Spencer Teppy was passionate about dentistry and taking care of his family. The couple hosted many gatherings of family and friends. And this one continues onward where he is waiving extradition from Illinois to Ohio. He being McKee. The ex-husband of an Ohio woman charged this weekend with the murders of her and her husband waived his right to an extradition hearing Monday in Illinois. 39-year-old Michael David McKeef, a doctor from Chicago, has been charged with premeditated aggravated murder in the shooting deaths of 39-year-old Monique Teppy, whom he divorced in 2017, and dentist Dr. Spencer Teppy, 37, in their Columbus home on December 30th. McKee appeared in court in Winnebago County, Illinois, where he has been jailed since his arrest on last Saturday. He appeared expressionless while he walked into the courtroom wearing a yellow jumpsuit with shackles around his wrists. Judge Donald Shriver did not say when McKee will be returned to Ohio, but he scheduled a hearing for January 19th to confirm the status of the transfer. The Winnebago County Sheriff's Office will coordinate McKee's return to Franklin County, where the trial will take place, according to Tom Jakeway, the court administrator for the 17th Judicial Circuit Court of Illinois. His arrest caps off nearly 2 weeks of speculation surrounding the mysterious killings that attracted national attention. No obvious signs of forced entry were found at the Teppy's home. Police also said no weapon was found there, and murder-suicide was not suspected. Further, nothing was stolen, and the couple's two young children and their dog were left unharmed in the home. In a statement, their family said the arrest was an important step toward justice and that they trusted the justice system to hold the person accountable. Monique and Spencer remain at the center of our hearts, and we carry forward their love as we surround and protect the two children they leave behind, it said. We will continue to honor their lives and the light they brought into this world. Dispatchers first received calls of concern when Spencer Teppy didn't show up on December 30th at the dental practice where he worked in Athens, a college town of about 75 miles southeast of Columbus. His manager told police his tardiness was out of character. It was when Columbus police conducted a wellness check at the home later that day that they discovered the couple's bullet-stricken bodies on the second floor. Official reports from the Franklin County Coroner's Office won't be completed for several weeks, but a spokesperson said last week they died in an apparent homicide by gunshot wounds. Police released security footage on Tuesday of a person of interest dressed in a dark hoodie-like colored pants walking in an alley near the couple's home between 2 and 5 a.m., which was the window of time in which investigators believed the two were attacked. The release generated dozens of tips and took a manhunt across multiple state lines to McKee's apartment. McKee and Monique Teppy, then Monique Sabatursky, married in 2015. According to Franklin County court records, they filed for divorce 2 years later. According to the Teppy's obituaries, Monique married Spencer in 2020. Family members described the couple as extraordinary people whose lives were filled with love and deep connection to others. Spencer Teppy was a graduate of the Ohio State University, where he was a member of the American Dental Association and had been involved with the Big Brothers Big Sisters organization. Monique Teppy was described as a loving parent, a loving, patient, and joyful mother, an avid baker, and a thoughtful planner. And There's one more story left on that one, and that's the same doctor is a he's facing another lawsuit in Nevada. Separate from these murder charges in Ohio, he's facing another lawsuit in Nevada. Interesting. Okay. A doctor accused of shooting and killing his ex-wife and her husband in Ohio has ties to Las Vegas. The bodies of Monique Tepe and her husband Dennis Spencer Tepe were found in their Columbus, Ohio home on December 30th. Two small children were found unharmed in the house, according to court records. In an affidavit, Columbus police stated surveillance footage showed a person of interest walking in the alley near the couple's home. After a 10-day manhunt, Michael McKee was arrested in Rockford, Illinois. According to court records, McKee and Monique were married in 2015, divorced in 2017, didn't have any children together. Divorce was granted to Monique on the grounds of incompatibility. Monique met and married Spencer in December 2020, and the couple had just celebrated their 5th wedding anniversary, according to their obituary. McKee graduated from Ohio State University, completing his residency at the Virginia Tech Carleton Clinic and completed a fellowship at the University of Maryland Medical Center before coming to Las Vegas. Records show the Nevada State Board of Medical Examiners issued a medical license to McKee on March 6, 2023, and that it expired June 30th of 2025. He practiced at Las Vegas Surgical Associates. Court records show that McKee is also a part of a medical malpractice suit, involving that clinic. According to the complaint, Guillermo Schwantz was a patient at Las Vegas Surgical Associates and was looking for treatment related to lower extremity venous insufficiency. He says he underwent laser treatment on July 5th, 2023, which was performed by Andrea Egtarafi, who was allegedly under the supervision of McKee and another doctor. Swans alleges that McKee and the other doctor did not properly train or supervise Egtarafi, and that caused a catheter or device to shear or fracture, leaving an 8.6-inch portion of the device in the plaintiff's body. Ouch. Schwann states that he was then taken by ambulance to an acute care hospital to have emergency surgery to remove the device. In response to the lawsuit, attorneys for Egtarafi denied the allegations and stated that McKee was on site at the time of the incident, but was not registered as her supervising physician. Court records show that the attorneys had difficulty locating McKee to serve him. September 30th, process server goes to McKee's home near Rainbow Boulevard and West Cheyenne Avenue. There was no answer when he knocked on the door. The home was quiet and all the blinds were closed. October 1st, process server heard the television on, but when he knocked on the door, the TV was turned off, and there was no response at the front door. October 9th, process server knocked on the door, but there was no answer and no movement, so he left his contact card at the door. The process server then saw McKee's medical license had expired, so he tried to contact the medical board but was unable to reach anyone. He then spoke with another doctor who said he had no idea where McKee was and that McKee had just disappeared. After that attempt, the process server searched for any other addresses associated with McKee and found an apartment near Bermuda Road and East Star Avenue. October 13th, process server stops by the Star Avenue address and it was all quiet with no movement. At least it would not provide the process server with any information. October 15th, Process service stops by the apartment again. There was no answer. It was quiet. There was no movement, and the blinds were closed. October 18th, process service spoke to a neighbor and was told McKee does not live there, and she didn't know him. Court records show the judge granted an order to serve McKee by publication. They also state that as of July 5th, 2026, it is unknown on who, if anyone, will represent Dr. McKee. The court docket shows that a status check for the trial readiness for the medical malpractice lawsuit is set for April 28th of 2027. As for the murder charges, McKee made his first court appearance on Monday. He is waived extradition and will be transferred from Illinois to face those charges. He did not enter a plea, but Assistant Public Defender Carrie Poirier told the judge that he intended to plead not guilty. The next hearing in that case originally set for January 19th. However, court records show the court was informed that it would not be possible to extradite him to Franklin County, Ohio by that date. All right. Let's cover the case against him in Las Vegas. Honestly, I'll have to say that Michael McKee's finances are gonna see a lot of zeros going to the plaintiff. I mean, I can only imagine the pain and anguish that plaintiff was going through with with that emergency surgery. As far as the double murder charges, all things are linking back to Michael McKee. Things aren't looking good for him. Things are not looking well for him at all. So I'm gonna go ahead and put this out there right now. Michael McKee better have a real good defense attorney because he is definitely gonna need it. All right. I said I was gonna stick to the big four, and I'm doing just that. Had so much to cover tonight, but these four huge cases is what's really standing out. All right, next up is the case in Virginia against Brandon Banfield in the Au Pair Affair murder trial. Give you a heads up here on what this case is about. Okay. And okay, good. Going to Fairfax, Virginia. A Virginia man is facing life in prison if he's convicted in the deaths of his wife and another man. Sounds familiar, doesn't it? Brendan Banfield is charged with aggravated murder in the February 2023 deaths of Christine Banfield and Joseph Ryan. Prosecutors allege the murders were part of a larger scheme between Brandon and au pair Juliana Perez Magalhaes, who were having an affair. On the day of the killings, Magalhaes called 911 at least 3 times, hanging up twice before reporting the emergency on the third call. Brandon then spoke into the phone and said that he shot a man because he believed because the man stabbed his wife, according to the Associated Press. Authorities soon arrived at the Banfield's home in Herndon, Virginia, and found that Ryan had been fatally shot and Christine suffered from stab wounds. She was taken to the hospital where she died. The story that Margulies told police raised suspicion. A months long investigation revealed that Margulies and Brandon were lovers. Prosecutors say the two schemed to kill Christine by luring a man to the house to play out a rape fantasy. Ryan accepted the invitation, thinking he was meeting Christine for violent sex play, and brought a knife and restraints. Margulies was arrested in October 2023 for the death of Ryan. Brandon was arrested nearly a year later in September 2024 for the deaths of Christine and Ryan. The following month, Margulies pleaded guilty to manslaughter in the death of Ryan. In a video obtained by NBC News, she said the plan was masterminded by Brandon to avoid a divorce. And that statement was only the beginning of Margulies flipping on on Banfield. Yep, she testified that it was Brendan Banfield's plan to get rid of his wife. I will spare you all the 2 hours and change of watching the testimony, and I will give you the information as we have it here. The young woman who pleaded guilty to her on Tuesday testified against her former boyfriend. Juliana Perez Margulies testified against Brendan Banfield, who was charged with aggravated murder in the deaths of his wife, Christine Banfield, and Joseph Ryan. Margulies pleaded guilty to manslaughter in what prosecutors have described as a murder plot. Margulies says she moved in with the Banfield family in October 2021 and initially had little interaction with Brendan. We barely spoke, she told the jury. My relationship was mostly with Christine and the Banfield's daughter. Brendan and I barely spoke at all. That changed nearly a year later. Margulies testified that her physical and sexual relationship with Brandon began in August of 2022. While Brandon kept the relationship a secret, Margulies had posted images and videos on social media obscuring her boyfriend's identity with an emoji. Margulies testified that she did not initially view the relationship as serious, but said Brandon soon began discussing long-term plans, including marriage and having children. Margulies said Brendan described his marriage to Christine in negative terms, saying that she didn't seem to care about where he was, what he was doing. She didn't seem to care about him at all. Divorce, she said, wasn't an option because of financial and custody concerns. Margulies said Brendan began to form a plan to get rid of Christine, first raising the idea while the two were on a trip to New York. Margulies said she initially thought Brandon was joking, but in the coming months, he began to elaborate on his plans. He said he wasn't going to hire anybody because that is something throughout the investigation that can be discovered easily, and that he heard of a website called FetLife. Prosecutors say Margulies and Brendan created a profile on FetLife.com under the name Anastasia9 using Christine's computer. Margulies testified that they posed as Christine, uploaded photos, and began messaging users on the platform. Brendan's goal, Margulies said, was to find someone who participated in BDSM, who plays aggressive or likes playing with blood, and invite them to the house under the guise of being Christine. Magalhaes testified that the couple deliberately used Christine's devices and only only accessed them when she was home to avoid detection. Joe Ryan, who used a website under the name Taco Supreme 7000, responded to the messages believing he was talking to Christine. In messages shared with the jury, Magalhaes read messages aloud to the jury saying that she and Brendan asked Ryan to come to the Banfield home, bringing restraints and a knife. Christine was later found dead from stab wounds, and Ryan was fatally shot after arriving at the home. Brendan has pleaded not guilty, and his attorney acknowledged during opening statements that Banfield had an affair with Magalhaes, but denied involvement in the killings. Ooh, what a tangled web. How you doing, Amy Lynn? And yeah, you're right. It's not looking good for him at all. Ugh. I mean, his chances of actually surviving this case is slim and none. And I just saw Slim leaving off the first bus smoking in in Virginia. Good to see you. And yeah, like Amy Lynn said, I'm gonna go ahead and hit that up real quick. Amy Lynn said, yeah, it's not looking good for him at all. Which is something I brought up to my wife in that particular case, and another that I'm gonna pull up as well. It's that risk reward thing I made mention on a previous edition of the Bite. Should Brendan Banfield testify in his own defense? It's that risk reward factor being the risk. He tells a story. He takes his shot. He takes a shot. He tells his story the way it happened, and in the end, there's that possibility that a jury will find him guilty. Despite despite what he said, they're still weighing the evidence as well. But on the flip side of that is a possibility that he could actually say, "No, I'm not gonna testify." The jury weighs that evidence, and he's still found guilty. Risk reward. What do you think, guys? Should he do it? All right. Next up, we are going to cover the Uvalde school massacre trial, where former school officer Adrian Gonzales is standing trial. 29 charges of failing to act. Let's just put it that way. Failure to act. Okay, great. Nueces County, Texas. Former school resource officer is the first person to stand trial in connection with the Uvalde school shooting. Gonzales is charged with 29 counts of child endangerment and abandonment. 29 counts, ladies and gentlemen. Oh, goodness, let me move my foot. Yeah. 29 counts of child endangerment and abandonment after 19 children and 2 teachers were killed in a mass shooting at Robb Elementary in 2022. Gonzales and former Uvalde Schools police chief Pete Arredondo were indicted by a grand jury in June 2024. They are the only 2 people indicted in the shooting. Gonzales was one of the first officers to arrive on the scene among more than 400 officers who responded and waited more than 70 minutes before confronting the shooter. Arredondo was the on-site commander that on that day, according to a report from the Associated Press. He's charged with 10 counts of abandoning or endangering a child. Arredondo failed to identify an active shooting, did not follow his training, and made decisions that slowed the police response to stop a gunman who was hunting victims, according to the indictment. A trial date is not set for Arredondo. Records surrounding the shooting revealed terrified students inside a classroom called 911 as parents begged officers to go in. A tactical team of officers eventually went into the classroom and killed the shooter. Each charge against Gonzales carries up to 2 years in jail if convicted. Now, I may not look like the smartest guy in the room, but I do know a little basic math here. 29 charges, each one carrying a 2-year sentence. This guy could see himself behind bars 58 years. 58 years. This is another case where you have to ask, do you think Gonzales should testify in his own defense? Because 58 years behind bars for 2 counts for 29 counts of child abandonment and endangerment because you were slow in acting regarding an active shooter. Bruh. Not something you want to mess with. Okay. One last one of the big ones here. We're going to New Jersey for the Mansion murders trial. Paul Caneiro is standing trial. And boy, oh boy, so much going on in this one. It's not funny. Ooh. Okay. And his brother's family before setting both of their homes on fire, facing life in prison if he's convicted. Paul Caneiro is facing multiple charges, including 4 counts of first-degree murder in the deaths of 50-year-old Keith Caneiro, his sister-in-law, 45-year-old Jennifer, 8-year-old niece Sophia, and 11-year-old nephew Jesse. Prosecutors alleged Paul fatally shot Keith and stabbed his niece and nephew to death on November 20th, 2018, according to the affidavit. An investigation revealed that Paul and Keith were business partners. The day before the murders, Keith had emailed Paul about missing money from business accounts. A business associate told investigators that Keith also wanted to sell one of their two companies, and he was frustrated with Paul and the amount of money Paul spent from their business accounts. An office manager also told detectives the brothers had arguments over money. In search of Paul's home, detectives found a container holding clothing and a latex glove with red stains consistent with blood in his basement. An affidavit says a 9mm unspent projectile was also found in the clothes. The same type of ammunition was located in Paul's home and used in the murders, according to investigators. Paul rejected a plea offer in 2024, according to the Asbury Park Press. Prosecutors reportedly offered to recommend he be sentenced to life without the possibility of parole in exchange for pleading guilty to 4 counts of murder. And as a recent update, court was canceled today due to a juror's illness. To no one's surprise, it usually all goes back to money. All goes back to money, whether it's business or personal. If all this evidence that is against Caneiro pans out, yeah, he can see himself spending the rest of his life behind bars. So I've got that, and I will try to bring all the other stories that I had lined up for tonight, possibly this weekend. Because as you caught me on a couple of occasions during this episode, I've been yawning. I've been tired. I've been burning the midnight oil on a lot of different things right now. But I appreciate you guys coming here and do me a favor, spread the word. Bethea'S Byte right now is not going anywhere. I promise you that. Right now, let me go ahead and drop my closing statement before I get out of here. Man, 4 huge cases like that, I've got to close it up and close it up right. All right, here we go. Among the cases covered tonight, chief among them are 4 cases resulting in 4 tragedies, which gives us 4 reminders that evil doesn't always kick down the door. Sometimes evil walks in wearing a badge, or carrying a family name, or holding a medical license, or even bearing the promises of love. In Texas, parents still wait for accountability because their children never came home. In New Jersey, a family tree was cut down by the roots. In Ohio, 2 young children will grow up with a story no child should ever have to carry. And in Virginia, a marriage, a life, and a stranger's trust were all weaponized in a plot that defies comprehension. Different facts, different motives, different states. But the same question echoes through every courtroom. When the people we trust fail us, who stands up? When people we love betray us, who speaks for the victims? When the truth is twisted, Who untangles it? Ladies and gentlemen, that is why these trials matter. Not because they're sensational, but because they force us to confront the uncomfortable truth that justice is fragile and must be defended every single day. Tonight, we don't look away. Tonight, we bear witness. Tonight, we remember the names, the lives, the families, and the future stolen. And until the verdicts come down, we remain vigilant. We remain compassionate. We remain committed. Because this is the final word. And justice, real justice, is never just a headline. It's a promise. All right, guys, I want to thank you all so much for joining me here this evening. And I can't wait to do this again one more time with you. So until we do that, remember where you are, the drama-free true crime destination, where we do this with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.